So we are starting our summer reading program, and that starts June 1st. We have our kickoff, and that's from 1 to 6 p.m. You can come in here. It's for all ages, adults and kids and babies, any age. You can come in and join the summer reading program. For our kickoff, we're going to have a popcorn bar, and we'll also have a community art project that we're going to put on our window in the children's area, so you can contribute to that if you like also. We will be doing a lot of the summer reading program on an app called Beanstack, where you can record your reading and do book reviews and other stuff like that. If you do not like apps, you do not like computers, we also will have paper copies for anyone to do if they would prefer that. But in the summer reading program, I do once a week a drawing. It's based on just a random drawing for those that have finished books, gone to programs at the library, done book reviews. That's how you can get a chance to win, and you get an entry for each book review or coming to any adult program at the library. So I do a weekly drawing of $25 in chamber bucks and a couple books, and then at the end you'll get an ebook reader. The winner will get an ebook reader. So we'll do a drawing and the winner will get an ebook reader. All right, part of summer reading program, the theme is find your voice. So we're going to be doing some writing and some poetry and different things throughout the program. We're going to have a book haiku. Haiku is poetry, 5 syllables for the first line, 7 for the second, and 5 for the last line. So what that is we're going to do a haiku that describes a book, either your favorite, your least favorite, whatever you're passionate about, any book, but you're describing it through a haiku. If you don't want to write a haiku, we have a match the book with the haiku that's already written. So we'll have different things that'll be on display at the library from June to July. We also have a program called Shut Up and Write. So if you are interested in writing but just feel that you don't have the space or the time, we've carved out a bit of time for you that you can come into the library and have a quiet place to write. We'll be doing that Tuesday, June 6th at 5 o'clock. You can write for an hour, and if you want to stay and talk about your writing with someone, you can do that also, or you can leave after an hour. We are having a movie matinee June 7th at 2 o'clock p.m. and we are seeing Mrs. Harris Goes to Paris. So this is a woman who does find what she loves, couture dresses, although she has a budget of a cleaning lady, so she eventually finds how to get to Paris and get the dress she loves. We have Mary McSwain Steele and Steve Steele here. They are going to be doing a program called Telling Your Life Story, Memoir Writing. So if you've ever been interested in maybe talking about what you have done in your past, writing your memoirs or anything like that, you can come to this. They will give you tips for productive writing habits, memory prompts, story structure, helpful apps, and avoiding writer's block, and publishing tips. Come on in.
And when was that?
That is June 19th at 6 o'clock p.m.
Thank you.
Yep, it's a Monday night at 6 o'clock p.m. We also have Cherie Hari Arts coming in. She is the education assistant at the University of Iowa Office of the State Archaeologist. And she is going to do a program called Ancient Technology in Iowa. How did they do that? So she'll be talking about flint knapping, pottery making, bone tools, unique uses for plants, and a lot more. So that is June 9th at 2 o'clock p.m. It's in the afternoon. We are also going to make a decoupage journal cover. So this is an little art project, arts and craft project, June 12th at 6 o'clock p.m. Registration is necessary for this because I'll need the right amount of supplies for everyone to do their journal cover. Our book discussion this month in June, it's June 22nd. It's a Thursday night at 6 o'clock. We normally have it at Monday, but this month we're moving it to Thursday. It's Say You're One of Them by Uwem Akpan. He is an African writer, and he has written a series of short stories. There's 5 short stories in this book based on the voices of children within different African countries. So it's telling their story. If you're interested in that, we have large print, regular print, and we do have an audio book version also. So let me know about that. Amy's Tech Talk, Let's Talk Twitter. So if you're interested in knowing anything about Twitter, you've heard a lot about it, I'm sure, recently, but you may not have ever been on it. If you're interested in knowing anything about it, that is June 29th, it's a Thursday at 2:30 p.m. We also have our band book discussion. That's June 29th, it's Thursday at 6 p.m. And we are doing Gender Queer by Maya Kababe. So if you're interested in that, let us know and we can get you a copy of that book. This is a graphic novel. So, all right, done with stuff that's happening in June. So now we have Dalton J. Kidd here of Kidd Law Firm, which is in the Lakes area, right? Yep. He is here to talk to you about some issues and some law that might be important to older Iowans. And we're going to thank SMU for being here and taping this. That's wonderful. Thank you so much. And right now we'll have Dalton J. Kidd come up.
Thank you. Good afternoon. As she said, my name is Dalton Kidd. I'm an attorney that I actually have two offices now. I practice out of Arnold's Park. We were in Spirit Lake. We moved there the first of the year pretty much. And then I also practice down in Emmitsburg a couple days a week as well. And just a little background about me. I'm from the Lakes area originally, and then I went to law school, practiced in Des Moines for about 4 or 5 years, and then moved back up here, I think it was in about 2015, and started my own practice. So one of the areas that I practice in a lot is estate planning and things that are similar to that. And today we're going to talk about what essentially some advanced directives. Mostly we're going to be talking about power of attorneys. And so what they are, how they work, some of the ins and outs, and I'm going to try to give you, I have a PowerPoint presentation that I'm part of the Elder Law Section Council for the State of Iowa State Bar Association, and they've kind of created some slides that I'm going to base off of, but I'll try to give you some pointers as well of things that I see that are some issues and how we kind of handle those. I can't provide you legal advice because I'm technically not representing you or anything, so we'll try to answer a few questions, but about anything specific I probably can't get into it too much detail, but I'll try to do my best here. So let's get started here. So the Elder Law section is part of the Iowa State Bar Association. And what that is it's an organization of attorneys in the state of Iowa. I would say 95% of attorneys in Iowa belong to it. It's a great organization, provides a lot of resources for attorneys and then also for the public as well, whether it's different forms or if you've ever dealt with attorneys before, you've probably gotten some forms and you're like, I have no idea what this means, and I've read it 5 times. And so they provide some things to the public as well that kind of talk more in layman's terms about what they mean and things like that. So we kind of already done the welcome and introductions, so we'll talk about a few different documents and kind of their relation to estate planning, what a fiduciary is, the financial power of attorney, the healthcare power of attorney, living will, final Disposition Act, and then we'll do some questions and answers at the end. So what is a fiduciary? The definition: a person having a duty created by his or her undertaking to act for another's benefit in good faith, not the fiduciary's benefit or profit. So fiduciaries are anything from like a trustee to a power of attorney. Some financial advisors can be fiduciaries in some points too. So essentially you're taking decision making for somebody else, but you're doing it, it has to be for their benefit. Kind of explain that there, and then you have a standard of care as well. And so essentially you're looking, like I said, you're looking out for that person's best interest where they can't make decisions, or you have a certain expertise to help make those decisions for them. And regarding healthcare, it's a little bit different than some of the other financial things you normally get involved with. But essentially, you're making decisions for that person when they're unable to, and after knowing what their desires are, as well as kind of looking at the full picture to see what would be in their best interests. We kind of talked about it a little bit. Attorneys in fact or agents, that's usually your power of attorney. Representative payee for federal benefit. So sometimes you can have your Social Security or some other things like that that they can make decisions for you on that. Executor under a will is another good example. I do note for a lot of people, I know we're not really going to get into last will and testaments, but people say, well, I listed my executor in my will, so they have power. They actually do not have any power until your will is probated and the court issues letters of appointment. So just because you name them does not mean that they actually have any power until the court appoints them or approves them. So administrator is just kind of the other name for an executor. If you don't have a will, it's called an administrator for your estate. Guardian and conservator, that's kind of the flip side of the coin of power of attorney. They're a little bit more of a last resort and more specific things, but we'll get into when those come into play. And then a trustee, you know, a lot of times it's somebody like when you list executor in your will, you have a trustee, except they do not need court approval, but your trust documents will say when their powers kick in. Usually, you know, if I set up a revocable trust for somebody, which is they have complete control, can change it and everything like that, they're usually their own trustee as well. But if they appoint a successor trustee, then that person kicks in, and then their duties are similar. They have to look out for the person's best interests and also take into account the terms of the trust. Like I said, today we'll focus on the advanced directives, power of attorneys, living will, and then final disposition law. That is kind of a weird area of the law that most people don't understand, that you cannot name what you want to have happen with your remains in your will. I mean, you could, but it's not how should I say it? It's not binding, but you can list the person you want to make those decisions regarding your remains. A lot of times when I bring that document up to people, they kind of shake their head, and I don't need it. And it's kind of one of those things, though, that if you don't have it, as long as you understand that your spouse is going to be the first person and then your kids, if you're fine with that, that's okay. But if you want somebody else making those decisions, or you want one of the children to make the decision, this document can be very important. I was just in a continuing education yesterday on an ethics deal, and it kind of reminds me of one thing he said, reminds me of this document. It's not important, but when it goes bad, it goes really bad. And so you want to watch. It is a document that I always offer to people, whether they take it or not, at least they understand the situation there. Because a lot of people don't realize that, and obviously you can imagine you pass away and one kid wants one thing and another wants another, and it can get very litigious and can cost a lot of money and cause a lot of heartbreak in the family as well. So what is a financial power of attorney? A financial POA is a legal document in which one person, who's called the principal, gives authority to make decisions with respect to his or her financial affairs to another person called the agent. So about 10 years ago, the state of Iowa changed around their wording on some of this, and it used to be called attorney in fact is your power of attorney, but now they use the word agent. Financial power of attorney is just kind of like what it says. It's regarding financial things. It's bank accounts, signing a deed, things like that. You know, your retirement accounts, beneficiary designations, and again, the kind of the pole star that we look at is, you know, it has to be in the best interests of the principal, who is the person that is designating these people to make decisions for them. Advantages for Iowans of having a POA. First one is a POA allows a person to plan for potential incapacity resulting in an inability to manage his or her financial affairs. There's a future slide that will talk about when this goes into effect a little bit, but I use these all the time. I recommend everybody, whether you have $10 or $100 million, to have a financial power of attorney. And one of the things that happens that sometimes people don't think about is, let's say you don't have much for assets and you get in a car accident and it's the other person's fault and you're incapacitated, and you know you get a big judgment, or you know a couple $100,000 or something. you want somebody that's going to be able to make decisions regarding your financial affairs if you're unable to there. It allows a person to name someone to act as his or her behalf in the event incapacity actually occurs. So incapacity, I think we get into it a little bit here, but is unable to make decisions on your own. So a car accident is one where you're unconscious. Another one is, and that could be temporary or it can be a permanent type incapacity. Another one that comes up a lot of times is, Alzheimer's or dementia too. And we get, doctor's notes or whatever, or have them do an evaluation about whether or not they feel that you have the capacity to make financial decisions on your own and for your own best interests. You heard me kind of talk about the flip side of the coin of the guardianship and conservatorship. So if you don't have a power of attorney and you need somebody to make these decisions for you, the next thing you have to do is you have to go to court to get a conservator, which is the kind of the similar to what the financial power of attorney is. So a conservator looks over your assets. You have to file, and I got a couple of these going right now, and sometimes you're in a hurry, and I'll just tell you, they do not go very quickly usually. So usually you have to have a petition signed by somebody, they have to serve that person, and then they have to wait 20 days before a hearing can be held whether or not they have capacity. So you can be out a month pretty easily on getting a conservatorship put in place. Kind of talked about that, and then the expense too. You're going through the court process. There's a filing fee. There's a few other things. Your attorney fees to get that prepared are a lot more than what you're going to do if you just have a financial power of attorney. Power of attorney abuse. Again, that Polestar reasoning of what is in the best interest of the principal. So the power of attorney, there is some teeth in it as well, that if the person that you list as power of attorney, you are designating that person while you have capacity. So it's somebody that you want to trust or you do trust. And so while their power is not endless, this is something that if there is a problem and somebody says, no, they shouldn't be power of attorney, well, the court's going to look at who did you select when you were able to make decisions on your own for this power of attorney. And so they're going to probably, 9 times out of 10, they're going to follow what your wishes are there. If you do a conservatorship, you can petition, somebody would petition to be conservator, but then it's going to be up to the court to decide who that person is going to actually be. What are the legal requirements for a valid POA? Must be signed by the principal or by another person in the principal's presence and at the principal's discretion or direction. You hardly ever see anybody besides the principal. I've had it happen a couple times. Normally it's somebody that is unable to write on their own. A lot of times it doesn't actually have to be a signature. It can be kind of an X or a mark, we call it. But there are occasions where somebody cannot sign, but it has to be in their presence, and they have to affirm somehow that they want to do that. Otherwise, it's not clear whether or not they have capacity. And so I always try to make sure, sometimes we try to video these things if I'm concerned about capacity or some other issues so that it's clear. You don't want to have to get in a fight after the fact on these and say, well, you want it pretty concrete about who you've selected, and that so nobody can test it, because that can drag out and cause a lot of issues. And then it would be notarized as well. Sometimes you can have 2 signatures. So if it's an emergency, sometimes you can have 2 people sign as witnesses. But a lot of times we just use as a notary public. When does the POA begin and when does it end? There's 2 choices with the financial power of attorney. You can have it effective immediately, or you can become only when it becomes incapacitated, unless the POA expressly states otherwise. So we call that a springing power. So a lot of times for most people, they may say, well, I want to list this person as my power of attorney for my finances, but you know what? I want to sign my own checks. I want to do my own stuff. I can do everything now. I only want it when it's clear I'm not able to do so on my own. And so then it only goes into effect when when you're unable to make decisions on your own. Other people are like, you know what, my son or daughter helps with a lot of my finances. I would prefer them to be able to do some of this stuff, to sign on my behalf. Sometimes people go south for the winter and their accounts are up here, and they want somebody to have authority to be able to do that. I have one client that they go to Arizona in the winter, and he's kind of semi-retired now, but he had a lot of business things and things that real estate he owned in his personal name. He'd sell it, but to sign the deed, instead of having to try to send a deed down to him in Arizona and back, we had a power of attorney his son that could do that. And so some of it's convenience to have it effective immediately. Other times if we're doing something and we know that there's going to be a big surgery or something like that, we can just go ahead and say it's effective immediately. To get that springing part to have it effective when you're incapacitated, you will need to get a doctor's evaluation that you're unable to make those decisions at that time. So. And then I think it says it does end upon death. And that's one thing a lot of people don't realize is power of attorneys, they only end upon death. So you say mom or dad has passed away, well, I'm power of attorney, I'm going to go to the bank and we're going to change the accounts and distribute out the money to the kids. They're not going to accept that. At that point, that account it doesn't become frozen, but essentially it does, unless you have a few other things involved there about an authorized signer and things like that. And the banks have gotten a lot more protective on this because of abuse by people, and they take the money out and they run. And so that power of attorney ends upon death. And at that point, depending on how you have your estate plan, your will and your trust, or a trust and some other things and beneficiary designations, nobody can make those decisions at that point. So it's important to kind of mesh these power of attorneys with the rest of your estate plan as well. So. The principal may designate any competent adult or organizational entity such as a bank as an agent. Agent may be either a relative or non-relative. A lot of times it's a spouse first and then one or more of the kids after that. I always kind of tell the stories more of the medical power of attorney, which we'll get into, but it's very similar here. I would say 90% of the people list their spouse if they have one first, and then they will list one or more of the kids. And generally, for some reason, it always seems like it's the oldest kid if they list one. And I had a client that I went to high school with their youngest daughter, and they had 3 kids, and he listed his youngest daughter. And I kind of looked at it, I go, well, that's fine. I go, I'm not sure why you want to do that. Usually, you do want the other kids. He goes, well, for medical reasons, he goes, the other 2 are going to hold on too long. I know she'll pull the plug on me right away, and that's what I want. So, you can have a non-relative sometimes, but it needs to be somebody you trust. I mean, you're going to give them some authority that, you list them and you're unable to make decisions. Likely the court or if there's a contest on this, they're going to side with who you picked. So you want to make sure that it's somebody that you trust very well. You can have a bank or an entity do that. I generally don't. First, a lot of times they try to charge for it more than, technically, I don't think that they can really charge for power of attorney, but if you say you're not going to pay them, chances are they're not going to want to do it anyway, so it's not even worth putting them listed in there. We kind of talked about this. What are the characteristics of a good agent? Trustworthy, sufficiently knowledgeable and experienced to make needed financial decisions. Some people, not all, but I do have some clients that say, look, my son's a financial advisor. I think it's a good idea for him to run the finances. Or they run a business or something like that. They know how to keep books. And especially if you have multiple kids and maybe a spouse alive still there too. they may have to give an accounting, and so we want somebody that's going to keep track of this and kind of balance the checkbook and do all that stuff and keep an idea of looking at your investment accounts and things like that and checking on the assets. It can be a little bit of a time consuming depending on what your assets are. So you don't necessarily have to talk to them beforehand, but a lot of people will. They want to make sure that that person's willing to serve. Generally, I like to have somebody younger, if not the primary power of attorney, but the secondary or contingent, just because if that first person passes away first, and we don't have anybody listed below, then we're back to going to the court to get a conservatorship if we don't have anybody listed. Located not far from principal or easily accessible. This has become less and less of an issue in the last couple of years. As you guys know too, you can sign a lot of stuff, whether DocuSign or Zoom meetings on things. The main thing that you really can't anymore are, in Iowa anyways, are deeds. We have to record the original. There is something called Iowa Land Records that you can record real estate documents electronically, but under the rules, you are supposed to have the original in your possession. So I said, well, it doesn't do me a lot of good. I need to have that original. I can't have a scanned copy of it and then file that to record it. So location is not as big as it used to be, but it is still important for some things, especially like real estate, or sometimes it's good to meet in person with that power of attorney with a bank, with some other things to walk through things, and you can get them handled a little quicker. Willing to carry out the principal's wishes and preferences, not his or her own. So you want somebody that is not going to be kind of dominant and say, well, this is the way I would want it done. They want to be somebody that's amenable, that they would understand your lifestyle, understand your family dynamics some too. It's important to know that as well, and that they're going to follow what you think. If you were not around to make those decisions, say they would probably make the same decision I would. Able to manage possible conflicts among family members and others. So some people do choose to have a non-family member be that, because if you list one child and there's multiple, there can be some friction there. A lot of times the kids are listed. Sometimes you can list more than one person, but then you're going to run into that same issue a little bit of some conflicting views on who should make the decision, or no, mom or dad wanted this, or my brother wanted this, not that. So sometimes if you think that your kids or the beneficiaries of your estate are going to fight over this or cause problems, you may want somebody outside the family to be the person that's willing to take some angry phone calls every once in a while, but be firm in what they're in looking out for your best interests. Co-agents and successor agents. So you can list more than one person. In my forms, I have usually 3 choices if you list more than one person. You can have unanimous consent. So if you list 3 people, all 3 have to agree. All 3 people have to sign every document. If you list 3 people, I have where you could do majority rule. And so 2 out of 3 have to sign. Sometimes if one child lives on the east or west coast, it's just easier to not have them sign. Usually I try to get them at least to consent either by phone or email, just to say, yeah, I agree with that decision. Or the other one is independent authority, where any of the 3 or 2 can sign. And now the other ones aren't technically bound by that, but unless I shouldn't say that. The decision is made and the bank or whoever can accept it, but the other ones, if for some reason there was a breach of the fiduciary duty, would still have a claim against that person for that decision. So they wouldn't be necessarily liable for it unless they consented to it somehow. Successor agents, I usually tell people to list at least 2. So you have your primary, your first person, and then a second if they are unable to. And that's not just, prior to you needing this, it's after the fact. Some of these power of attorneys I've dealt with, they've been in force for 10, 20 years. And so sometimes people's lives change, they move, they pass away, they say, look, this has become more cumbersome than I can handle, and so it's good to list at least 2 different people there. I highly recommend at least 2, and sometimes more than that, depending on the situation. Again, yeah, it talks about resigns, dies, becomes incapacitated, or is not qualified to serve. They have the same authority as your primary designee. So what can the agent do? It's pretty broad, and that's on purpose. The reason is, I don't know how many times we go through things and we plan, and something comes up that you just never would have ever thought was going to come up. And so you want some flexibility, and you want this fairly broad to be able to do certain things. So. But you can limit it as well, and so I always tell people, read the document, read through it all. I'd say most of the time they don't. They just ask me questions on it. But you should think about if there's certain things that, you have a business and one child runs that business, and you want to make sure that child, there's kind of a plan that goes forward. And so your power of attorney is maybe the other kids or a spouse or something like that maybe they don't have authority over the business type deals, and then your board of directors and your officers of that company run that. That's one example of things that, considering what powers, I would say 95% of the time, though, people just choose all the powers, because like I said, you just don't know what's going to come up, and then they would rather just, it's somebody you're supposed to trust anyway, so they're okay with them making a lot of those decisions. Some of them are only if they're expressly stated in the power of attorney. Other ones are more general. There's a Iowa Code chapter over this financial power of attorney, and so it lists all those. Usually the forms will list a lot of these powers as well. So what can an agent do? Creating, amending, revoking, or terminating an inter vivos trust, or a living trust, or revocable trust. That one, that's one that sometimes people will say, I don't want them to have that power. So if you have a revocable trust, you may not want them to be able to amend that, because technically they could change it to say, everything goes to them instead. Now they would be a breach of their fiduciary duty, but they could still do it. And then your other beneficiaries are left with the task of hiring an attorney and fighting that and going through all that. So that's one that sometimes you may want to not do. Making a gift. Generally for gifts, I'd say that a couple different things. One is, you can follow the gifting pattern that you've done and continue to do so. So if you, we're not talking about your $100 at Christmas or anything like that, or something like that. We're talking more, in the thousands of dollars of gifting. I have some clients that they'll gift, $5,000 a year to each of their kids. They want to see them use it. They'll give it to their grandkids too, because they want to see them use that for a trip or something like that. So you want your power of attorney to continue to do so if you have a pattern that you've done that. Now, if it was once and it was 10 years ago, that's probably not going to be considered a pattern where they're going to be able to follow. Creating or changing a beneficiary designation. Again, this is like changing your will or your trust, because your beneficiary designation trumps what your will or trust says. So it's a contract essentially with a bank or whatever, and so they follow that, not what's in your other documents. So that's another one you want to be a little bit careful with. Designating authority granted under a power of attorney, waiving the principal's right to be a beneficiary of a joint and survivor annuity. You don't see that too often, but every once in a while. Exercising fiduciary duties that the principal has authority to delegate, and disclaiming property. Those are kind of some general ones. You don't see a lot of those. Mostly for those, you're looking at your really big estates where, for tax reasons, there may be some reasons you don't want to have some assets coming into your estate, and so you can disclaim as if you predeceased that person. So, agent's duties a little bit more here. They include acting in accordance with the principal's reasonable expectations to the extent known, and if unknown, the principal's best interests, acting in good faith and acting within a scope of authority granted in the power of attorney. Well, I don't know about you, but that's pretty broad language. I think you could argue either way on a lot of that stuff. So, but you got to have something in there. And so it's basically, it's kind of the, what would they do unto others as you want done type rule there. So, can an agent's misuse of authority be challenged? Yes. So normally it's going to be people that would normally receive your assets, your spouse, your kids, things like that. So these aren't foolproof where they can just run and do whatever and nobody can say anything ever. You can contest them if they're doing something that you don't think is in the best interest of the principal. And they can be held liable for the loss of violation of those duties as well. Must a bank or other financial institution accept a POA? Generally, yes. There's a few exceptions. They need to make sure it's executed correctly, and things like that. But generally, they must accept those. I would say most of the time they do, unless they may kind of bat an eye or roll their eyes a little bit if it's a handwritten power of attorney and stuff like that rather than a legal form. But I usually don't have much problems with the power of attorneys with the banks. And then if they don't and your power of attorney is executed correctly, usually a short letter from your attorney saying, well, if you don't accept this, we can file suit and then you have to pay our attorney's fees, and that usually gets them to move pretty quickly. Does the Power of Attorney Act apply to a healthcare power of attorney? No. So that we're going to get into the healthcare power of attorney in just a second. That's under a whole different chapter. A lot of the same rules and regulations kind of apply. And you can name different people, and sometimes you do. I'd say most people list the same people for the healthcare and the financial power of attorney, but you certainly can list different ones. One example of that is sometimes I have some clients that, like I said, one son's a banker or financial person, and their daughter or their other son is in the medical field, and they go, well, he's in the medical field, I'd rather have them make that decisions regarding medical and just what they're good at, because they have, some of these decisions can be fairly tough too. So. Is there a form that can be used to create a POA? There is a form actually directly in the statute. I use a different form. My firm in Des Moines, I still do a lot of work with them. They kind of created their own when this new statute came out, and so I kind of stole that from them and kind of use it. I just mostly because out of convenience, I know what's in it. I've read it enough times, and but I would say for most people, the statutory form or kind of the default form is probably going to be good. But again, you got to read these things. Take the 10-15 minutes and go through it, because sometimes you may go, "Whoa, I didn't know it did that," and or you may have questions. Most of the times people just run through their power of attorneys, or they'll just print one off online and don't know exactly what's in it, and just, like I said, 10 to 15 minutes of reading that through, maybe looking up your questions, can save you a lot of grief and heartache in the end there. Kind of the same on that there, so seeking legal advice. And like I said, I use a little bit modified form. It's got a lot of the same language, but so it doesn't necessarily have to be that form that's in the statute. And July 1, 2014 is when they really redid the whole statute. Anything before that is still in force. So if you had one that was created then, it still is in force as long as it was executed correctly under the requirements at the time it was executed. So that's the financial power of attorney. The next one is, I'm not sure what we're doing on time here. I'll try to get through this one too, and so we can get some time for questions. Healthcare power of attorney. So this is a durable power of attorney, healthcare, and then living will, and we'll talk about that as well. So again, the principal is the person designating other people to make decisions on their behalf. Attorney in fact, so it did not they did not change the language in that statute to match the financial power of attorney. Now it's called an agent, but agent, attorney in fact are just synonymous. If you use one or the other, it's not going to cause any issue. Durable means that if the principal becomes disabled or incapacitated, the attorney in fact still has the ability to act on behalf of the principal. So one big thing, and I think we'll get to that here, is when it goes into effect. And that is one difference between the healthcare and the financial power of attorney. But again, you're giving someone an authority to make medical and health decisions on your behalf according to your wishes. If you have some, they must act in your best interest, and then they do have a priority over a guardian. So, subject to if there's some litigation, then it gets back to that best interest, and sometimes we do run into those problems. But a lot of times people will list a guardian. If they pre-list a guardian, it'll be the same person. But we do run into the situation where there's a guardian appointed and there's a medical power of attorney, and so technically the power of attorney is supposed to be priority because you listed them, where the guardian is somebody appointed by the court that somebody's petitioned to do that. So I have run into where the medical power of attorney maybe wasn't doing what they were supposed to. It was debatable, and so sometimes people will file a petition for a guardianship and kind of combine it with trying to get the medical power of attorney person removed as well. So. How to make a power of attorney: must have capacity and be competent, so over 18 years of age, be competent, must be in writing, handwritten, typed, or a form. Handwritten one, I always kind of cringe if I see that, because you're kind of opening up yourself to problems over people contesting that. So. Must contain the name of the person authorized to act, powers and responsibilities given to the attorney in fact, signature of the principal, the date signed, and signed in the presence of a notary or two witnesses. So the reason that you have the two options for the signed in the presence of is sometimes these come into play in emergencies, as you can imagine, with healthcare issues, and so maybe they can't get a notary to where they're at, and so they need to sign them right away, and so two disinterested witnesses can sign rather than a notary. Who cannot be witnesses? Healthcare provider attending the principal on the date of signing. That's a little vague. Sometimes we do have the nurse or somebody in there, or they'll grab somebody from administration at the hospital to come and be a witness to it. An employee of a healthcare provider, again, a lot of times if it's an emergency, we'll probably just do it just to get it done, and somebody has to contest it to say that's not that would not be enforceable. The attorney in fact, though, you never want to have the person that you're listing be the person that's witnessing your signature. Somebody less than 18, and at least one should be a non-relative. So I usually don't have the kids sign as witnesses as well, because you're opening up yourself to some problems there. A healthcare provider attending the principal, so usually we won't have the doctor do it, especially because they're the one making diagnosis about your capacity, and so there's a little bit of conflict there. And then, they talk a little bit more about employees of healthcare providers, but I would say I've seen it quite a few times where they are, and it's one of those deals again that who's really going to contest on that, and that they did not witness your signature. So, however, some medical places have told their employees, they're like, we don't want you there to do that. We don't want the liability and things like that. So sometimes we have to find somebody else. I've on more than one occasion just grabbed somebody and said, hey, can you be a witness for this really quick? So, but it does bring home the point too of doing these well in advance. So you already have this in place if you go into the hospital. So going to an attorney or getting the form online and reviewing it and doing it with your neighbor or having it signed or something. Anytime there's an emergency, we're always opening ourselves up to potential litigation or people to contest it. Who should have copies? So we didn't really talk about this with the financial power of attorney, so I'll kind of bring that into here. The attorney in fact and the alternate. So I usually give that to them so they know that they have this power. Doctor and other healthcare providers, usually give them to your primary care physician. Family members and friends, you can. The principal, obviously, you keep that. And make easily accessible to family and friends. A lot of those same things, except for the doctor and potentially the friends for the medical power of attorney, or for the financial power of attorney, apply here as well. I usually tell people that you should keep a copy in your safety deposit box, but probably not your original, especially the financial power of attorney, because if you're incapacitated and the original's in there and we can't find any other copies, they won't allow you to get into the box to get the power of attorney to show that you have the authority to do so. Revocation, termination can be revoked at any time. So as long as, a little misnomer, as long as you have capacity. So if you would become incapacitated and one of your kids grabs your arm and kind of signs the revocation, that's not going to apply. But otherwise, it can be revoked as long as you have capacity. Orally or in writing, obviously in writing is going to be a lot better if you're going to change this to make clear. A lot of times for revocation or termination, we'll just do a new power of attorney, and it basically will supersede the previous one. Tell the attorney in fact and others, interested persons, doctors, yeah, that would be an important one to tell the doctor if it's changed, if you change somebody. You can do that while you're getting that care. It is presumed that you have capacity to revoke. And then terminates upon disability or incapacity unless it is durable power of attorney and upon principal's death. So almost all the ones we do are under durable power of attorney, so they would continue on if you're unable to make decisions. Kind of talked about this a little bit. Do not place in a safety deposit box. Like I said, I usually will give a couple copies out and then keep a copy in there, so in case you need one. In this day and age too, for my clients, if we do them, I say, okay, you signed everything. I'm going to keep this for a day or two. We're going to scan it so we have digital copies of everything so we can email it to people if they're on vacation, if they're this or that. We'll keep copies of it. Travel, other states will recognize, so these do apply to other states. It's a little trickier if you become a resident of another state. In that case, you probably should at least talk to an attorney in that state and say, look, is this going to apply? They're probably going to say, it's going to cost more time for me to go through your Iowa attorney or power of attorney to decide, let's just do a new one in our state. But you know, if you become incapacitated and then move or whatever there, then it should apply over there. So. The nice thing about it is the no court oversight, and we get into that with a guardianship, conservatorship. You have to do annual reports. You have to do a background check. The guardianship and conservatorship laws changed. I think it was January 1, 2020. They went into effect, and they're very cumbersome anymore. And part of that was just they were really worried about elder abuse and people taking advantage of things, and so. Sometimes we do want the conservatorship and guardianship because you may say, you know what, my kids, I love them, but they may fight over this. I want a court supervising this, seeing the assets each year, doing an annual report, giving notice to all the kids about what's going on. I don't know how many times I hear from from kids, well, my brother's the power of attorney and he won't even give me any information at all. So sometimes the guardianship and conservatorship, it can be a little bit better way to go if you want that oversight of the court, because then you already have it in place. and then you can go directly to that court file and file something rather than waiting, filing a lawsuit, getting them served, and all sorts of other stuff there. So, yeah, communicate wishes and trust the individual appointed. I have clients go both ways on this. Sometimes they're like, I'm not even going to tell this person that they're the power of attorney. Other times I tell them, well, you probably should let them know just so they're not blindsided by it, especially if they may say, I do not want to do this at all. Sometimes the kids will not want to serve as the medical power of attorney because making those decisions, again, gets back to my friend from high school. She was fine with it. She's like, yep, I know he wants to go. I'm fine with that. Other kids may hang on for longer than you would want to have done there too. So, nominating an alternate, and then HIPAA. Usually the form has, you've probably all heard of HIPAA. It's privacy notice of medical records. So this allows you to get medical records as well as the power of attorney. So not just making decisions, but actually getting your records to look at things. So sometimes people will want to limit that. There's a box, I think it's in the slides, of one of the, on the medical power of attorney form. Let's see, it's behavioral health, so mental health, sexually transmitted diseases, and I think there's one other one, a very private medical things that you may not want your medical power of attorney to have that information. I would say most of the time you want them to have as much information as possible, but sometimes in certain circumstances maybe you don't want them to have that information. Living will. So I'm going to start with the fact that my old firm in Des Moines, we kind of went away from doing living wills, and I'll get into why here a little bit. But a living will is a written declaration that informs medical personnel that certain life-sustaining procedures should be withheld or withdrawn if the person is in a terminal condition and unable to decide for himself or herself. It's a directive to the medical staff, and you are not nominating a person. So it's a separate document, but a lot of times we will, if people want them, they are in the form with the medical power of attorney, so it can be one document together with that. Any medical procedure, treatment, or intervention that uses mechanical or artificial means to sustain, restore, or supplant a spontaneous vital function and would serve only to prolong the dying process. So they are going to keep you comfortable, so it's not like they take away pain medication or anything like that. I still do these for people if they're adamant about it. Some people are like, I do not want to be kept alive longer than necessary. I've lived a good life. I don't want to be on a machine. I don't. And the one thing I would tell them, and it goes back to the medical power of attorney, is the living will, the language is very generic, and I can't even tell you if I would know. I could say 100% one way or the other. It talks about being beyond a medical degree of certainty. Well, every doctor is going to have a little bit different take on that. And so you may want your medical power of attorney to be the one making that decision, because they're going to know, is this a car accident that happened a week ago and you're still doing a lot in life? Or has this been 6 months or 9 months or a year and there's just no way, or you've been suffering for a lot of other things and it's time. Your medical power of attorney can make that decision. And so rather than having a doctor say whether or not you have a terminal medical situation there. So again, the language there, an incurable or irreversible condition that results in death within a relatively short period of time, or a comatose state from which there can be no recovery to a reasonable degree of medical certainty. Well, like we talked about, that can be a little bit hard to decide that. So we kind of went away from doing those. I've done them a little bit more since I moved back up here. I give people the option. I said, really, there's no right or wrong answer here. It's just, if you are adamant that you do not want to be kept alive, yep, we'll do it. And then your medical power of attorney can take that into consideration too. So on the flip side of it, if you have one, your medical power of attorney can say, look, they want to go. I'm not gonna get in the way of this. So. How to make a living will, almost the same as the other ones. Be competent, 18 or older, signed by declarant in front of 2 witnesses or a notary, in writing and dated. Who cannot be witnesses? Healthcare provider, again, employee of healthcare provider, less than 18. At least 1 witness shall not be a relative. So they did change the law from earlier in 1992. Most people have updated them since then, since it's been over 30 years ago. But they are still valid if you have one of the older ones there. Revoking a living will, anytime, anyway, just like the medical power of attorney, you do have to have some capacity. I mean, there's a presumption of capacity, but you can revoke it just pretty much the same way as a healthcare power of attorney. Family consent laws, I'll kind of go through these quickly here. So if no living will, treatment decisions may be made by the following person in order. Persons designated in a power of attorney, guardian. One other problem with a guardianship is you have to get court approval on these, and so getting that in front of a judge and getting them to sign off on it, again, that's why the medical power of attorney is a lot better option, I would say 95% of the time, than a guardianship. If there's none there, then we're going to the spouse, then a majority of the adult children or parent or parents, an adult brother or sister. One thing that I think a lot of people probably remember, I think it's probably been over 10 years ago, of, they say, well, I don't know if I need a medical power of attorney or something, I think her name was Terry Schiavo down in Florida. And you remember that big fight they had? It was on TV almost daily about the spouse wanting to let her go and the family just heart-wrenching deal. And so I remember, I think I was in law school when it happened. I remember our professor saying, this is why you do these power of attorneys, so you don't run into these situations. Iowa physician orders for scope of treatment. I hardly ever see these or have requests for these, but it does give you some say in what your treatment choices, ensures the patient's wishes are fulfilled at the prescribed time. So these are more something you'd probably want to discuss with your doctor if you have certain requests on things of your medical procedures there. So. A DNR, do not resuscitate. I think most people have all heard about that. It's not the same thing as an advanced directive. Hospitals and long-term care facilities are required to give you CPR if anyone's heart or breathing stops, unless there's a DNR order on file. So this is different than the living will and the medical power of attorney. Normally, you're seeing these put into place, towards the end of life, or that death may be kind of imminent here. So. Can only be written by a doctor with permission of the patient, his healthcare agent, or family. Again, if you have a guardianship, you have to get court order to give permission to get one of those. The out-of-hospital DNR is very similar. You get a lot of the same things, have the doctor set it up for you, provide a copy to the decision makers. Again, one thing that overall people sometimes get worried about the living will and the do not resuscitate is, well, I don't want to be in a lot of pain when I don't, and none of these documents will withhold pain medication or things like that to keep you comfortable. They just will not keep your life support going. The Department of Public Health, like I said, it's not so much of a legal document with the DNRs. A lot of times people don't even come to an attorney to do that because the form's pretty straightforward. And you can usually find that online, or you can talk to the department. Usually your doctor will have one at their office as well. Whoops. So like I said, I'd say a lot of people just, they just ask me, okay, who do I list, what, and they don't read through these. I do suggest you at least read through them, every once in a while, and just to make sure you're comfortable with it, because they can be changed. I mean, you can update them, you can modify these slightly if you want for your particular situation. And you may want to have a conversation with, I think it's always good to have with family about what your wishes are. We talk about burial, and we'll get into that a little bit more there, but what you want to have done. A lot of people will pre-purchase their burial plots and their burial needs so that it's clear and you've already paid for it, so the kids or your beneficiaries or heirs don't have to find money to do that, because sometimes your bank account nobody may be able to get into that when you pass away, and so if you've prepaid some of that stuff, then they don't have to pay their own money towards it and try to get reimbursed at that point. So. Final Disposition Act. So this is something that came about in 2008 that states the durable power of attorney for health care may include a declaration that names a designee and alternates to make decisions concerning final disposition. Whenever I say final disposition documents, people kind of look at me funny and what that is. So in Iowa, you can't say in your will or your power of attorneys, because remember, they end upon death anyways, what you want to have done with your remains. But you can designate a person and then an alternate to be the one to make those decisions. So, a lot of times people, the problem was, people would say, well, I want to be my ashes to be scattered on Jack Trice Stadium or Kinnick Stadium. And well, you're not going to get in there to be able to do that. You get some people, they're like, I want my ashes to sit at the White House just to bother whoever the president is at that time. Obviously that's not going to happen. So you can have somebody make the decision regarding your burial remains. So this is the order of this, is the designee. So if you do the document, then the person you designate is that person to make decisions. If you do not, then the surviving spouse, if they are unable to or do not want to, then your children, kind of majority rule. Again, a lot of times there could be some litigation regarding that. Then your parents, and then grandchildren, siblings, grandparent, next of kin, any person who knows the individual county medical examiner. So that's the list that goes down in order of who gets to make that decision. Before we go to that, so I would suggest doing this document, especially if you have kind of second marriages in the family, or you have kids that may not see eye to eye. They may love each other to death, but they maybe have different outlooks on life. And honestly, you don't know how, especially with kids, you don't know how their parents' death is going to affect them, and making, whether they're going to be making rational decisions. Always explaining to them the prepaid burial things, that really helps, because it really shows what you wanted to have done. I have a case right now where this has come up. I can't really get into the details, but it's been dragging on for years. There's talk of digging up the remains and moving them, and one side is just, they are just distraught that would ever happen. Some people have very strong religious views about cremation and things like that. So that it's, again, one of those deals that 90% of the time there's probably never going to be a problem, but when there's a problem, it's a really bad problem. And so it's a one-page document. I usually tell people, if you're okay with your spouse making those decisions, and then your kids equally, go ahead. But if you're concerned that one of your kids may want to do something different, or somebody wants to do something spiteful, litigation The fastest growing litigation in the United States is about probate litigation, or kind of through estate planning, because the person we want to ask the questions of is deceased, so we can't ask what their intent actually was. And as you guys can probably imagine, people will bite their tongue and mom and dad pass away, and then you did this to me 20 years ago, and things come out. Or when I practiced in Des Moines, Polk County is the only county in Iowa that has a probate judge that all they do is probate work. And the people that would come in there fighting, they were spending thousands and thousands of dollars fighting over things that were worth a couple $100. I mean, it's very emotional. It's worse than family law. It can be really, really bad. So making sure your estate plan and making sure it's clear, having some of those conversations with the people you want, that you love and care about, that would be involved in it is a good thing to do. And again, prepaying what you want to have done or listing what you want to have done can save a lot of heartache and grief for your loved ones after you pass away. So. All right, so I think we're right at an hour, but I can take a few questions if you guys would like. Yes?
The last thing you talked about, plan of disposition, if you had a prepaid funeral with your wishes already, that would suffice for this, would it?
So it's a little bit of an open-ended question. I had to do a ton of research on this law. I actually talked with law professors at the University of Iowa Law School about this too, and they say it was very poorly written law. And there's some ambiguity in some things, because I told them my situation. First of all, they said, well, that's just a horrible, and they said, we didn't like some of the language in that deal, so it's a little open. The person you designate would make the decision, so you would want to designate somebody that will follow what you had done. They don't necessarily have to, you could prepay burial and they could say, no, I want to bury him somewhere else, so that money would be wasted essentially, or if you can get a reimbursement, that could cause a lot of problems there too. Now, if it goes to court, and there is, it's a little open-ended about, again, I'm not quite telling you there's a strong answer here about what's reasonable and what was actually in the best interest here, whether or not it's reasonable to not follow what you prepaid. That's a little bit of an open-ended question right now. So I would tell you to, always designate somebody that you know is going to follow your wishes and let them know what your wishes are. If you don't have that document, then it will be your spouse or then your kids. Hopefully, they're going to look, this is what you already prepaid or whatever. But one of them will say, well, no, mom or dad told me later on that they wish they would have never done that. And so it can cause some problems that way.
Is it a form that's available online?
I don't know if that one is. I think it is. It's not part of the healthcare power of attorney chapter of the code. So if you go to, I think it's iowacourts.gov, and then there's for the public, and then a lot of these statutory forms are there. So, but it is just usually it's a one-page document, and I should say you can't list more than one person. So you can't list 2 or 3. You can list one, and then you can list a successor, and then another successor. But it's only one person because they want just that one to make the decision, which I don't know if that's really in all situations. I think it should be up to the person, because in my situation, the surviving spouse and maybe the parents together should have been listed rather than just one or the other. And so, maybe it's a good idea to have more than one person, but under the law right now, you can only list one at a time. Yes?
We moved from Arkansas 10 years ago, or 8, or whatever it was. And we had down there a lawyer draw up a power of attorney and health power of attorney and that sort of thing. And I took it to him.
We took it to an attorney here when we moved here.
In Iowa, questioning whether this was all valid. in this state. And you mentioned travel up there, and that made me kind of nervous. Without seeing it, would it be?
Well, he said it was okay, so.
He said it was okay.
I would say it probably is. And travel, I think what they were meaning in the slide is if you're not changing residence, you're actually you're on vacation or something like that. When you change your residence, it may be a little bit, they're supposed to still follow. Generally, the rule of thumb for those, if they were effective and done correctly under the law in the state that you did them in, they should transfer over to now. So again, I can't give you legal advice for sure. I would say, most attorneys are only going to charge $100, $200 to do medical and financial power of attorney, so it may not be a bad, for some peace of mind to have Iowans.
He ran through it very quickly, but I'd like to know if it's.
Yeah, I would say in general it probably is, but I can't tell you for sure. So.
What firm are you, sorry, in Des Moines, you said you're still affiliated with the firm?
Yeah, we have some cases together still. I left on good terms. I got tired of driving back in the Sundays on the summer. Duncan Green firm.
And what's your hourly fee?
Well, that depends a little bit. So.
Right, I get that, but I'm just wondering what your hourly is.
It depends on the situation a little bit there. So.
You can talk to them afterwards if you want.
Yeah, I can give you a card and you can call and talk to it. So, yep. Yes.
As far as an organ donor, is it true that you have to die in the hospital in order for your organs to be harvested versus dying at home?
I'm not sure on that. That does bring up a point that on your medical power of attorney and your living will, there's a question on there about whether or not you want to be kept alive long enough to do organ donation. Regarding, I don't know for sure whether or not if you.
Who would you ask? I mean, who would know?
I think probably the medical examiner. Or the Department of Health. Iowa Department of Health would probably have that answer. Yep. So, and they're usually pretty easy to find online, and then they have a phone number there. That's probably where I would start. So.
Thank you.
Yes.
I would like to have a copy of what you just said up here because I couldn't write it out fast enough.
Okay. Yeah, I think I can probably email a copy.
Yep.
Okay, I don't email.
Okay.
It has to come snail mail.
Well, he could email it to me, and
Okay.
then I could get that to anyone who wants it, so just let me know. Okay?
Yeah.
Any other questions? All right. Well, thank you all very much.
All right, thank you guys. Drive safely back home, and thank you, SMU, for coming.